determining the general and specific meaning of law was discussed. However, legal normativity is not limited. In the first part of this work, entitled The Problem of Law, according to the main work Lessons of Introduction to Law, Fernando Jos Bronze, the problem of determining the general and specific meaning of law was discussed. However, legal normativity is not limited to these two meanings alone, but manifests itself equally as an authentic reality. That is, as a cultural being that is realized in practice. The way of being of law 1. Modalities of existence of the right, validity and its relationships with validity and effectiveness. The law exists by being in force, as already mentioned in nauseam throughout this epitome. The traditional maxim is repeated again. There is only one right, the one that can be said to be in force and none else. This means that the law will only be law when it can be said to be simultaneously valid and effective. Therefore, the mode of existence of legal normativity is its validity. In a broader sense, it will be the mode of validity of any and all cultural movements. This means that a culture will become effective when it reveals itself to be an effective and social dimension of our community praxis. Validity translates into a synthesis of two dimensions that are articulated dialectically, the dimension of validity and the dimension of effectiveness. This means that the law can only be said to be valid if it has these two dimensions, that is, if it is valid and effective. When it is stated that the law has a dimension of validity, the aim is to convey the idea that it is. Download by Brian Rodriguez. theboostbee@gmail.com. Lomo Orkestu 24,096,147. Machine translated by Google. In accordance with the set of values that are historically and culturally rooted in a concrete community. This dimension translates into the ideal aspect of validity or its axiological dimension. That is, the right is a duty. However, this axiological dimension is not sufficient to show that the law is valid in a given concrete community. The law is not floating in the clouds. It is rooted in the earth. As a Castanera Neves states, law is a being that is. In other words, legal normativity does not materialize historically and concretely in practice. Therefore, the sociological dimension of law is emphasized here. That is, its empirical or factual facet. The dimension of effectiveness, which translates into the implementation of the law in practice under penalty of it not being in force. Now, since law cannot be a pure ideality, can it be a mere order of effectiveness? The answer is negative. In the world of law, we do not find ourselves faced with simple cognitive expectations that do not admit any type of transgression. Normative expectations are rather counterfactual. That is, it is not because certain violations occur that they will be nullified. Therefore, the law allows, to a certain extent, the occurrence of transgressions. In fact, the greater the tolerance of the right to these offenses, the more effective it will be. 2. Normative modalities of law. Objective law and subjective law. Firstly, objective law corresponds to the intellection of a certain corpus juris as a historical cultural phenomenal entity that is rooted there. Therefore, translating the consideration of the current legal normativity as a being that should. Therefore, law is not just a set of legal norms, e.g. Portuguese law, European law, in short, any dogmatic legal area. Here, we, as citizens, always appear as recipients of this objective right, that is, of a certain corpus juris. On the other hand, we are also holders of rights, which are seen as rights in a subjective sense. Subjective right translates into the legal power to freely demand or demand from others a certain positive behavior, an action, a facere or negative omission, a non-facere, or even through a free will act, alone or integrated by an act of a public authority, triggering certain legal effects that are ineluctably imposed on the counterparty. Now, subjective law, viewed in a broad sense, can be diluted into two distinct parts. Subjective law stricto sensu, up to the understanding of legal positivism, and potestative law. But let's take a closer look at each of these two variants. But how is it possible to know the margin of tolerance for neglect? Now, this margin will always be unknown. There are values that leave the legal universe due to the lack of effectiveness of the law itself. However, this does not happen with all values, e.g. the exception of the right to life, as the concrete community no longer sees itself in those values. In subjective law stricto sensu, it is possible to find violations, as it always depends on an action or omission on the part of the other subject. Identifying this type of subjective law with natural and moral obligations, duties and rights. Thus, it is concluded that legal regulations, in order to be considered valid, will have to be valid and effective. However, it is further divided into relative rights and absolute rights, and it is important to distinguish these two concepts. While relative rights are opposed or imposed on one or more specific people, e.g. credit rights that emerge from a contract, rights absolutes are those that oppose or impose. Download by Brian Rodriguez. TheBoostBee@gmail.com. Lomorktustu 24,096,147. Machine translated by Google. To all members of a concrete community, that is, a general duty of abstention or universal passive obligation falls upon it, e.g. personality rights, real rights. On the contrary, potestative rights are, by definition, inviolable, since their exercise does not depend on an action or omission on the part of the other subject of the relationship. That subject is in a state of subjection, meaning that he does not may do to prevent the exercise of the potestative right. As for the effects that this type of subjective right intends to produce, they could be of a constitutive type. Whenever it creates a new relationship that did not exist, see Article 1370 credit card. Forced communion of walls and sharecropping walls, Article 1550 OCC. Right of servitude, modification. Whenever there is a change in an already existing legal relationship, e.g. Article 1568, change of servitude. 1794 judicial. Separation of people and goods, or extinctive. Whenever a pre-existing legal relationship ends, e.g. Article 1773, right to divorce. 3. Periods of objective law and periods of subjective law. Its evolution from a historical perspective. It is now important to highlight some historical notes about the times in which objective law was in force, and the times in which subjective law was in force, as well as its evolution throughout chronology. Subjective law began by not existing. It emerged incipiently in the Middle Ages, asserted itself communally in the modern age, and was conceptually thematized only in the 19th century. Subjective law has existed since the birth of legal science. Back in the Roman era, for Roman legal thought, law presented itself as an objective order that defined the status of people and determined the situation of things. However, this does not mean that the phenomenon of rights ownership did not exist. What really mattered at the time was the harmonious integration of the relevant positions in the community order, since man, only in reference to the Roman civitas, understood himself in a meaningful way. In the Middle Ages, with the separation between the church and the century, and associated with this, the theological idea that God and man, i.e., the creator and the creature, are ontologically distinct. Insofar as the human, integrating a concrete community, will disintegrate it because it also becomes autonomous in relation to the encompassing cosmos. The conditions were created to relativize the importance of the objective order, and it was this situation that allowed, albeit in an incipient way, to think about the phenomenon of the ownership of subjective rights. It would only be in the modern period that subjective rights would be fully assumed. Man asserted his autonomy before community orders. It was contractualism, linked to individualism, that allowed this new vision of law. Therefore, the legal order began to identify the set of subjectively entitled rights. It is, then, modern just naturalism that owes the creation of systems of subjective rights. With this legal doctrine, man began to understand himself as an individual with an autonomous practical subjectivity legally projected into the subjective rights that we are entitled to. However, This perspective did not exclusively mark 19th century legal thought. In fact, it is possible to identify, in this aspect, the 19th century as dualistic, since at this time two different lines emerged, one objective and the other subjective. The first is the normativist and legalist line, which was established under the influence of Jean-Jacques Rousseau and Charles de Montesquieu, and which argued that fundamental rights would only exist if they were recognized by objective law. The second is the liberal line, defended by John Locke and Immanuel Kant, which emphasizes the importance. Download by Brian Rodriguez. TheBoostBee@gmail.com. Lomorcus 24,096,147. Machine translated by Google. Material fundamental rights, such as the right to freedom or the right to property. Subjective, it will always have to respect its material basis to avoid falling into a situation of abuse of rights, that is, manipulations deliberately carried out in the different legal positions. 4. Relationship between the problem of the normative constitutive meaning of law and the ultimate foundation of legal normativity, the exemplary consideration of abuse of law. We now come to the conclusion that the greater the intensity of the affirmation of the individuality and autonomy of the human person, the greater the affirmation of subjective rights and the greater the disintegration of the objectively consecrated system. This means that while subjective law is associated with the sum pole, objective law is agreed with the commune pole. Another meaning lies in the fact that we can designate objective law as a centrifugal drive, as it sucks us into society, and subjective law as a centripetal pressure, as it repels us towards our autonomy and individuality. Therefore, legal normativity results from the dialectic between the two modalities, but the more or less accentuated hypertrophy of one of the scales leads to an unbalanced practice. If the accentuated hypertrophy and the affirmation of individualism, with the erasure of the community, leads to an anarchic enemy, the hypertrophy of objective law, in which the importance of community integration overrides autonomy and the maintenance of individuality, could lead to repressive totalitarianism. In conclusion, the famous criterion of abuse of rights, see Article 334 CCS, summarizes the dialectic between subjective law and objective law. It emerged at the end of legal positivism, a doctrine in which subjective rights were limited to formally normative ones. This means that even if the human person has the necessary capabilities to be the holder of rights. Download by Brian Rodriguez. TheBoostBee@gmail.com. Lomorcus 24,096,147. Machine translated by Google. 15th lesson pages. 607-681. The objective of legal normativity. The legal system. Law as a legal system, as has been mentioned ad nauseum throughout this work, and particularly with particular intensity in the previous chapter, the mode of existence of law. Law can only be recognized as such if we are in a position to say it positively. And once again we come across the characteristic statement of Fernando Jos Brons. There is only one right, which can be said to be in force and none else. Now, it is now important in this crucial and fundamental chapter to uncover where the content of legal normativity is objectified. The validity of the law is enshrined in a legal system. The legal order, viewed formally, appears intentionally in a legal system, and as a system that it is, it obviously has the notes of coherence and unity, ideas that design any type of system. It will then be under the clause that configure it as an order, that the law will regulate the worldly encounter of men within the community and who are integrated, refusing the chaos resulting from their clash with each other and, on the contrary, adopting a regulatory mechanism for their corporate life. This characterizing note of unity could also be said to be special, insofar as it is achieved in the dialectic in which all the strata that make up the legal system are interwoven. This note of unity will be achieved in the dimensional plurality of the legal system. It is now important to highlight some historical notes. While the positivist legal system, which was in force practically throughout the 19th century and even during the first half of the last century, was a one-dimensional system. That is, it appeared closed to present itself ready and finished with the intention of being later used and was composed of norms, prepositions that present a hypothetical conditional structure, and imperatives, commands issued by the legislative power. A system is now born that is completely antagonistic to the previous legal system in force. This new legal system presents unprecedented characteristics. Let's see. Firstly, it is open. Contrary to the typical closed system of positivism, it is a system more receptive to the novelty of legally relevant problems. Secondly, it is a material system. Opposing positivist formalism. Now the demands of meaning are also part of the legal system. Thirdly, it is multidimensional. The system is made up of several layers, all of which are binding on the jurist. Fourthly and finally, the new system is regressive. Being contrary to the progressive system characteristic of legal positivism, it is reconstituted from front to back through a dialectic in which there is a relationship between system and problem. That is, it must presuppose a system to solve a problem, and it will be the problem that will form the basis for the reconstitution of the legal system. However, the problem may be so unprecedented that the system is unable to resolve it, but he will always have to be able to pose it. He will have to possess the necessary strength that allows him to find something in the system that risks qualifying the problem as legally relevant. That is, transgressions that violate and call into question the values of freedom, autonomy, and equality. But what is it that allows the system to pose the problem? Now, it will be the meaning of the law. The legal system has the arduous task of making two contrary, but not contradictory, requirements compatible. The download by Brian Rodriguez. TheBoostBee@gmail.com. Lomo Orktustu 24,096,147. Machine translated by Google. Problem and order. The problem is always a question that has a disintegrating nature, a question animated by a centrifugal force. In the sense that problems are always singular, unique, unrepeatable. In short, they are always something new. Order, on the other hand, translates a unitary, deliberately integral rationalization and, therefore, is animated by a centripetal force, calling us to it. As the system is contrary, but not contradictory, it will be mobilized to appease this incompatibility. 2. The methodological relevance of the legal system. The legal system translates into a unitary complexity that is based on a primordial simplicity, as Darwinists classify the human being. Thus, the methodological relevance of the legal system takes effect in a system of legislation such as ours. The Portuguese legal system is a system of legislation in that it is mostly composed only of legal norms, although not exclusively. And this relevance is not minimal. She is maximum. But it is important, first of all, to decipher the meaning of the concept of methodology. This is broken down into three terms that give it meaning, goal, and the law aims to solve a problem. Odos, path, the steps that the lawyer must take to resolve the problem. And logos, rationality, type of thinking to mobilize to achieve this resolution. In the field of historicity, the logical deductive method, characteristic of the positivist doctrine, was exclusively enforced during the 19th century. Currently, this method is analogical, in that there is an inference from the particular to the particular, that is, a relationship between the system and the problem, which are on the same level. But what are the core issues of legal methodology? Now, there are two central questions. Analyze it then. Firstly, the jurist and in particular the judge must know what the type of thinking that they must mobilize to solve legally relevant problems. This first question therefore refers to the problem of rationality. The second question translates into the steps that the jurist will have to take from the initial confrontation with the case to the practical normatively appropriate response to it. We are now faced with the problem of the methodical scheme. This means that the jurist, in his arduous task of resolving legally relevant problems, and striving to intersubjectivize his subjectivity, foundation and objectification of the answers that the jurist gives to problems, will always have to take into account legal thought, to know what steps you will have to take to resolve the errors, and the system, to know what it should assume to be able to solve them. Therefore, we can never identify the resolution of a problem with a mere answer or decision. It is there. It is illimitable. However, the decision is configured only as the manifestation of a voluntas, a simple solution among several alternatives, always containing a load of subjectivity. Since it is the result of the human person, the decision will always have to be compressed by the segment of the judgment. Therefore, the sentences are fundamentally decision-making judgments, or judicial decisions. A judgment translates into a prudential consideration of concrete implementation, guided by a circumstantially adequate, argumentatively convincing, and legally normatively mentioned reasoning. This segment of the judgment refers to a foundation, and the judge finds it in the properly understood legal system. Although the national legal system is one of legislation, any decision cannot be subject to references to mere legal norms. The normal first step is to look for the answer to the problem in the law. However, this resolution intends for us to mobilize these norms as authentic. A norm must be in its ratio legis, that is, it will have. Download by Brian Rodriguez. TheBoostBee@gmail.com. Lomorcastu 24,096,147. Machine translated by Google. To be practical, but also in its ratio juris, that is, in its foundation. All norms must therefore be the objectification of a foundation. To be practical, but also in its ratio juris, that is, in its foundation. All norms must therefore be the objectification of a foundation. With practice not being enough, justification is always necessary. All norms must therefore be the objectification of a foundation. With practice not being enough, justification is always necessary. The foundation of any judicial decision always involves convening the properly understood system, that is, all articulated strata. All strata that make up the legal system correspond to either a foundation or a criterion, and depending on what it is, it will be different. A criterion translates into an operational model that provides a direct and immediate response to a legal problem, forming a solution scheme. The grounds, on the other hand, do not give a direct and immediate answer to the problem, but guide the jurist and allow him to justify the decision taken. They are meaningful requirements, and without them, the jurist will be unable to give a concrete legal answer to the legally relevant problems that he must try to resolve. 3. Analysis of the legal system in its understanding and current composition. 3.1. Stratum of the meaning of law. The first constituent stratum of the legal system integrates the law itself, identifying the ultimate foundation of legal normativity and the legal face of the human person. And the ultimate demands that characterize the human person are their individual face, polo suum, and their community face, polo commune, as has been intensively referred to throughout the work. The present stratum appears, in most cases, immediately, preempting all strata of the legal system, being the spirit that animates them. But there are also cases in which he is summoned immediately when it is not possible to find a mechanism capable of solving the problem, but it must always be capable of posing it. Therefore, the presumption of referentiality of the stratum of the meaning of law identifies the ultimate reference of an order of law. The meaning of legal normativity is to protect the human face, with the human person being the ultimate foundation of law. 3. Stratum of normative principles. It is important, first of all, to say what is meant by normative principles. They are demands of meaning that express the intentions and values that the law must assume and which it must strive to achieve. If the meaning of law corresponds to the predicative validity of an order of law, normative principles are the immediate characterization of this matrix, that is, the first already regulative projection. Hence the importance of distinguishing normative principles from values. While principles have a regulatory dimension of the meaning of law, values have immediate axiological dimension, that is, a mention of validity assumed by the meaning of law. Another important distinction is the comparison between the principles, regulations, and general principles of law. Normative principles are requirements of an axiological normative sense in which the validity of the system is based. They identify the authentic items of the practical normative validity of the system. They are constituted as foundations on which the judge must rely to present a solution to a problem that he or she is confronted with, not providing direct and immediate answers, and are mobilized in the methodological process as the basis of a resolution that may be preempted. They point to the odos as the light of a beacon in solving problems. They are open foundations for various solutions and practical intentions to follow in resolving a case. Download by Brian Rodriguez. TheBoostB@gmail.com. Lomoworktustu 24,096,147. Machine translated by Google. According to the problem of legality, we are faced with a principle of law when it presents three characteristics. Firstly, a consonance of reasoning. To be a normative principle, it will have to be in accordance with the ultimate requirements of the law, or that is, it must be the expression of the requirements that predicate an order of law. Secondly, a problematic consonance. The normative principle will have to have a practical use, capable of being mobilized to solve a legal problem, and of being a guiding requirement in response to that same neglect. And thirdly, an integrative character. It cannot admit any type of discrimination that is not legally normatively justified. Since one of the functions of the order of law and the legal system itself is community integration, however, discrimination may be made as long as it meets the reversibility requirements. A principle will only be of law when it respects the meaning of legal normativity, that is, the validity and effectiveness of normative principles. On the other hand, general principles of law are more general and abstract than the local norms of a given legal community and are not understood as requirements of meaning. They are nothing more than mere legal norms. According to the positivist vision of the 19th century, which remained until the jurisprudence of interests, in which both categories were merged, the general principles of law are epistemological conditions of the object of the given law, and their content did not transcend the core of the norm's core. Rather, it made them more intelligible. They were ready and closed criteria. Now, normative principles are fundamental for guiding the jurist in resolving legally relevant problems, not providing a solution. Rather, they allow us to justify the conclusion. Therefore, they have effective methodological relevance. They must be mobilized as a basis for solving concrete problems. Thus, all legal norms are limited by principles, under penalty of not being valid. If this were not the case, the jurist would be faced with invalid criteria and not with the law. It is now important to analyze the origin of normative principles. They are not nephilibatically in the clouds, as just naturalist legal thought defended. They are rather experientially materialized on earth through their exploration by legal thought when reflecting on solutions for resolving legally relevant problems that emerge on the community horizon and that go against the legal system itself. They are constituted based on the demands of meaning arising from the problems that occurred. On the other hand, normative principles are still marked by the note of historicity, being subject to the erosion of time and varying over the years according to the situation of the time in which they are based. But when do we find ourselves faced with authentic normative principles? According to the problem of justiciability, in order to be a principle of law, it must be justiciable, that is, capable of being controlled in court by the courts. However, the existence of mechanisms that control this operational requirement becomes urgent, and they translate into two dimensions. A formal dimension, in which control is operated by procedural rules, and a material dimension, a more demanding mechanism that refers to a methodological reflection, whose main purpose is to know which normative requirements allow us to mobilize to solve concrete problems, and, consequently, control the operability in court. To conclude, normative principles may have three classifications. They can be positive, those that are expressly or implicitly enshrined in law. Usually in a legal norm. Transpositive, they translate into the high watermark of a certain dogmatic area. That is, they are the sine qua non condition Download by Brian Rodriguez. TheBoostB@gmail.com. Lomor Tustu 24,096,147. Machine translated by Google, without which any dogmatic chair ceases to make sense, or superpositive, those that underlie all the others, and without which the law also ceases to have any meaning, finding itself on a more demanding plane and being associated with the sum pole and the commune pole. Depending on the perspective, any normative principle may simultaneously be covered by any of the classifications mentioned above. Regarding their presumption, normative principles bind the jurist through a presumption of validity. That is, we are bound to the principles because we presume that they are valid. 3.3. Stratum of legal norms. This stratum is considered the paradigmatic moment of objectification of the legal system, which is composed of legal norms. Norms translate into general and abstract legal criteria, and not foundations that provide an immediate response to the problem. Having a hypothetical conditional structure, they integrate a hypothesis, predicting a type of problem, and a statute, they abstractly confer a response to the problem formulated in the hypothesis. However, a legal norm only gains meaning when it is referred to its specific basis of validity, that is, to its normative principle. From a practical normative perspective, that is, in a system of legislation such as ours, the norm can be seen as a criterion for action. When they are immediately intelligible and unproblematically assumed, it is not strictly necessary for there to be a practical problem in order to be able to understand them. But they always become problematic. In terms of valuation, which highlights their semantic and syntactic grammatical dimension. On the other hand, it can also be seen as a practical judgmental valuation criterion. It turns out. Now the revelation of the arch foundation and telos purpose of the norm, that is, its archetheological understanding. The function of norms, by substantiating themselves and by substantiating the system itself, is to enforce in community practice the requirements constitutive of the principle of equality and resolve legally relevant problems. Legal norms are made up of two dimensions. The first is its imperative or command dimensi. When legal norms meet their telos, which are their legally relevant problems. The second is its rational or foundational dimensi. When legal norms meet their arch, which are nothing more than the foundations on which the problematization of the ratio juris, the verification of the fundamental principles of the norm, is b. During legal positivism, norms were premises, they were prius pracritivus. However, they are today legal normative criteria, that is, they are posterius. However, the legal norm is transcended upstream by the normative principles and downstream problems that give rise to it. It is also important to highlight the fact that until the jurisprudence of interests, the standards served as the starting point for methodological reflection, despite it already assuming the standard as a legal normative criterion. This stratum binds the jurist to the extent that he benefits from a presumption of authority, political potestas, since legal norms are emanated by political power, with both laws and politics itself having political constitutional authority. 3.4. Stratum of judicial jurisprudence. This stratum has a relevant importance in the role of redensification of the development of law. Downloaded by Brian Rodriguez. TheBoostB@gmail.com. Lomor Tustu 24,096,147. Machine translated by Google. A large set of problems are generated in the processes, leading to the creation of new standards and/or the exploration of principles. This stratum also reconstitutes legal normativity, since, through problems raised in the processes, it mediates the realization of normativity. This is the constitutive dimension of legal normativity that integrates the system. This layer of judicial jurisprudence judicatively implements current legality, reconstituting and developing it through jurisdictional precedents. Constitutive precedents become criteria that can be mobilized in the future for the resolution of subsequent similar cases. It also provides criteria and understands the sentence as a decision-making judgment, as an example of a response to a specific case. In a positive sense, The judge responds to the problem in accordance with the decisions taken by the majority doctrine, therefore not needing to justify his decision. The judge then refers to this current by analogy. In a negative sense, the judge, contrary to the majority doctrine, will assume the burden of counter-argumentation to substantiate the reason why he presented decisions that differ from the rest of the judicial doctrine, putting into question the principles of equal treatment, citizen security, and of inertia. Regarding its binding on the jurist, the stratum of judicial jurisprudence benefits from the presumption of fairness, insofar as we presume that the response sentence is fair and legally adequate. 3.5. Stratum of dogmatic doctrinal jurisprudence. Now, the function of dogmatics is to describe current law and propose solution models for problems that arise on the community horizon. During legal positivism, we were faced with reproductive dogmatics. Currently, dogmatics is configured as being authentically constitutive. It is the way of constituting the current legal normativity, and to this end it mobilizes the different strata of the legal system. However, it is urgent to make a distinction between authoritative dogmatics and foundational dogmatics. While the first manifested itself as purely reproductive dogmatics, limiting itself to describing the law and systematizing it, constructing concepts, the second was an authentically constitutive dogmatic and provided criteria and solution models that judges could use to resolve the problems they faced, and also provided foundations whenever it explained principles. The doctrine has 4 essential tasks. Let's see. Firstly, a stabilizing function. It institutionalizes the system, balancing it according to its openness. Secondly, a technical function. It allows the jurist to understand the demands of meaning, facilitating his task. Thirdly, a relief function. Frees the jurist from endless problematization. And finally, a control function. The doctrine will be able to control whether the sanctions it applies are fair or not. This stratum benefits from a presumption of rationality, understood in a similar way to the presumption of fairness, since here too the formation of currents, in this case doctrinal, and with similar processes takes place. The present stratum of the legal system is located on an intermediate plane between legal norms and sentences. It manifests the systematicity of law. Downloaded by Brian Rodriguez, theboosby@gmail.com. Lamore, Tuesday 24,096,147. Machine translated by Google. 3.6. Stratum of Legal Reality, 16th lesson pages. 683-746. Legal reality is not just an inert field of application of law. In fact, the way in which the law is put into practice by its recipients reconstitutes the current legal normativity. On the other hand, it is still composed of 3 types of reality: economic reality, political reality, and cultural reality. This stratum benefits from a presumption of effectiveness, as that without legal reality the law could not be said to be positive. 3.7. Procedural dimension stratum. The procedural dimension translates into the ultimate fulfillment of the technical argumentative operators that the jurist must resort to with the primary intention of adequately fulfilling the task he is responsible for. This objective is reflected in the judicative decision-making realization of the law. The method of constitution of the current legal regulations. The sources of law. 1. The problem and perspective of considering the sources of law, political constitutional perspective, and phenomenological normative perspective. The word source, originating from Cicero in the early days of Roman legal science, is an equivocal expression, as its interpretation can take several paths and whose analysis can culminate in several directions. This stratum of the procedural dimension of legal normativity benefits from a presumption of fairness or helpfulness. However, it is now important to contrast 2 perspectives on the problem of sources of law. On the one hand, a political constitutional perspective, the traditional theory of positivist legal thought, which will be overcome by a phenomenological normative perspective, the theory defended in the course. Well, analyze it now. The political constitutional perspective, highly influenced by legal positivism, is polarized in power. It is the legislator who is exclusively responsible for the crucial task of creating law and knowing which mechanisms can be authentically considered sources of law. In addition to the law, considered a direct and immediate legal source, any other source also depends exclusively on the will of the legislative power, and these are considered indirect and mediate sources. However, this is a contradictory and impoverishing perspective. It is not entirely. Downloaded by Brian Rodriguez, theboozb@gmail.com. Lomorque Peace D 24,096,147. Machine translated by Google. Adequate. This perspective is polarized in power, and the law only exists when it can be said to be positive. According to the later phenomenological normative perspective, the theory that really interests us in our course, and which surpasses the previous perspective, the problem of the sources of law is now faced from the validity category. The following question is now posed. What is the mode or modes of constitution of current legal normativity? Now, the law is a duty it is a validity that must be put into effect in community practice. Asking about the validity of the law is questioning which law is effectively assimilated by the praxis of a concrete community. That is, what is the set of criteria and foundations that a given community assimilates as its own, and without which, with or without the right, it would not be the same? This is a normative perspective because law is a validity, and it is phenomenological because we see law as an authentic phenomenon in that concrete historical context. 2. The constituent experience of law, material moment, moment of validity, and constituent moment. Institutes depend on reality. See, for example, the Family Institute. The law can never impose a global vision of the family, ignoring the current issues that arise, as is the case of single-parent families or marriage between of the same sex. 2.2. Validity moment. We cannot stop at the first moment, since the law does not intend to provide a purely effective response to problems with legal relevance. As it is not constituted as a variable that is purely effective, the moment of validity now arises. The law rather intends to provide a valid response to the problems that arise on the horizon of community practice. The law will have to consider reality to provide normatively adequate answers to legally relevant problems. But this answer will always have to meet the foundations and demands of meaning that shape and characterize an order of law. It is this phenomenon that guarantees the autonomy of the law, since it imposes limits on the dimensions of practice. But it can never be limited to validity alone, otherwise it would not be effective. The answer to the question raised by this second perspective, what is the way or ways in which the current legal normativity is constructed, depends on the analysis of 4 moments that are articulated. Dialectically, they are the material moment, the moment of validity, the moment constituent, and the moment of objectification. 2.1. Material moment or concrete social reality. The first is the material moment or concrete social reality. It is here that legally relevant problems emerge, and which require the law to provide a solution. Reality strongly influences and co-determines what the law is, and their own. 2.3. Constituent moment. It is in this third moment of the constituent experience of the current legal normativity, the constituent moment, that we will understand how the law is truly constituted and how it emerges in reality, and also which is the instance in which we primarily recognize legitimacy to take the dialectic in hand, in which the first 2 moments are entangled. The question that arises here is the following. What is the instance that will constitute the law in primordial terms in that? Downloaded by Brian Rodriguez, theboozb@gmail.com. Lomorque Peace D 24,096,147. Machine translated by Google. Concrete community. Now, there is never just one instance with exclusive legitimacy. That is, there is never just one way of creating the current legal normativity. It is important to compare which experiences constitute legality, customary experience, legislative experience, and jurisprudential experience. 1. 231. Customary legal experience. This type of experience that constitutes legality no longer exists. In traditional societies, which reviewed themselves in the past, law manifested itself as a legal custom, a communally stabilized, repeatedly observed and intersubjectively binding behavior. This means that this customary legal experience benefits from a social nature. Since the past is affirmed, here there is a constituent process that starts from a paradigmatic orientation and is repeated until only the irreducible is observed. This type of constituent experience is an authentic legal normativity that is observed. It is also important to highlight that it was with the rule of law of formal legality that legal normativity was reduced to mere legislation. This type of experience of constituting current legal norms presents certain characteristics. The law is objectified in norms or rules that provide abstract criteria capable of regulating them. These norms or rules presuppose a decision, and the rationality that predicates them is based on their inclusion in a systematic framework. They also have in the text in which they are enshrined their constitutive dimension, guaranteeing their continued rationality. Norms or rules are endowed with a power that assumes a certain strategy and that contributes to the politicization of law. 233. Jurisdictional legal experience. This constitutive experience of law benefits from a prudential nature, implies an autonomy of legal normativity, and the thought that reflects it, and the privileged temporal dimension is the present. 232. Legislative legal experience. Legal experience benefits from a state nature, insofar as it refers to political power, is fulfilled in the prescription of norms or rules, and aims to project itself into the future, due to its political finalistically reforming character. The constitution of law stands out from society and asserts itself as a politically oriented strategy that will be assumed by a government or a parliament. 1. CJM Aroso Linhares develops summaries. Here, the constitution of law occurs when legally relevant problems are resolved. This implies the intervention of a mediator who is responsible for making a judicial decision, and this solution must be appropriate to the heart of the controversy. The mediator may be objective, when he is called upon to project the presupposed validity into the problem he aims to solve, and subjective, since it is up to him to judge the legal merit of the claims of the conflicting parties. We can always find a polarizing experience in a concrete community, particularly in contemporary societies. In Romano-Germanic families, there is a legislative experience. Law is constituted and manifested. Downloaded by Brian Rodriguez, theboozebee@gmail.com. Lomort Peace D 24,096,147. Machine translated by Google. Primarily as it is prescribed in a system of legislation or civil law, like ours, already in Anglo-Saxon families, a jurisdictional experience is observed. Legal normativity is constituted and manifested as it takes place in a system of precedents or common law. However, these two different systems have become legally closer. On the other hand, legal custom, in current societies, is no longer configured as a primary criterion in any specific community. It continues to have relevance and importance, but it is no longer a polarizing experience. Although it continues to prove crucial in the area of public international law. Perform them. There is no other way of creating law that performs the same functions, considered essential and determining. These are the ordering and reforming functions. Only legislation presents the necessary conditions to guarantee political social order, required by current societies that constantly call for structural reforms, and planning and regulatory functions. Political social ordering implies programming for the future, and it is necessary to establish bodies, assign them powers, and which in turn will assume regulatory functions that guarantee such planning for future times. These two are essentially political functions, insofar as legislation is the only way of constituting legality that can prescribe the future. 2.3.4. Special reference to legislation. A. The importance of legislation in the constitution of legality. Within the scope of our corpus juris, legislation is the constituent mode par excellence of legality, highlighting several reasons of varying nature. According to political reasons, we are all heirs to the rule of law of formal legality, that is, to the normativist view of law. According to this perspective, one of the most important principles was the separation of powers, which emphasizes the relevance of legislation, which was assumed to be supreme power and overlapped with the other powers of the state, executive and judicial. Sociological reasons highlight that contemporary societies, unlike pre-modern societies, have a very strong planning nature that imposes institutionalization and regulation. Only legislation can plan and, thus, predict the future. According to functional reasons, there are certain functions that only the legislative power is able to perform. However, there are still two other functions that are essentially legal. First, an integration function. We find ourselves inserted in plural and fragmented societies, in which there is no authentic sharing of values. Now, if individuals cannot reach an agreement on the matter of values, legislation will have to tell them what is legal and what is illegal. And this distinction is important because there are more and more problems located in so-called gray areas, e.g., abortion. Secondly, a guarantee function, associated with criminal law in a strong way as it is the legal dogmatic chair that most affects individuals and can even, as a last resort, take away their freedom. It is therefore urgent that the law tells us which behaviors are considered crimes so that we know in advance the consequences of the acts we carry out. Once we foresee the future, only legislation guarantees us a certain security. And if this security did not exist, we would become an authentic object of the arrogance of political power. Downloaded by Brian Rodriguez, theboozb@gmail.com. Lomorx Peace D 24,096,147. Machine translated by Google. Despite the extremely important functions that we have just mentioned, the truth is that legislation has limits, and, therefore, it cannot be assumed as the only way of constituting current legal normativity. Contrary to what legal positivism defended, there are other sources of law in addition to legislation. B. The functional and normative limits of legislation has the necessary capacity to foresee all the problems that exist in community practice. Problems constantly arise for which the legislator has not provided for a criterion. This thought was generated by legal positivism. The positivist's first temptation was to assert that these problems were not legal, that is, whenever there was a breach without a pre-created norm to solve it, that problem was not considered legal. This phenomenon occurred because the system was closed and finished. It is also important to distinguish the limits that this constituent mode of current legal normativity presents, the formal limits and the normative limits. According to the formal limits of legislation, there are certain legal situations in which the legislator cannot intervene despite the law being able to do so. The legislator is functionally limited. He cannot claim to regulate all matters with legal importance. Although the law can interfere in certain relationships, as they have a legal relevance, in these same relationships the legislator cannot intervene infinitely and within all limits. There are areas that are limited to legislation and not to law. Currently, we speak of objective normative limits because we understand the legal system as open, there are no gaps. But the recognition that there is a problem for which the legislator has not provided a solution criterion. If for traditional thinking this was a serious problem, for the contemporary legislator it is not. In the case where there is no pre-available norm, the jurist seeks an answer to the problem in the other strata of the legal system. That is, he seeks a criterion in jurisprudence and doctrine. If there is not even a criterion, he will have to construct ex novo law through the stratum of normative principles and the meaning of the law. On the other hand, there are normative limits through which the legislator can intervene. However, legislation is limited at several levels. Let's see. Normative limits of validity. Objective normative limits. This type of normative limit of legislation corresponds to the traditional problem of gaps in the law. There are concrete cases, capable of being qualified as legally relevant, for which there is no legal norm pre-available by the system that assumes their relevance. That is, there is a problem but not a standard that solves it. The legislator's imagination is limited. He cannot, Norms are limited in terms of validity by normative principles. All standards must be the objectification of one or more principles. If this is not the case, they will not be valid standards and, consequently, will not be in force. The norm will have to be worked on in its telos and arch. If one norm frustrates principles, we find ourselves faced with an unjust law, a trans-systematic problem that rarely arises in the current rule of law. On the other hand, there are now more frequent concrete situations in which it is necessary to adapt the standard to the principles. Downloaded by Brian Rodriguez, theboostbee@gmail.com. Lomorx Piece D 24,096,147. Machine translated by Google. Specifically, under penalty of frustrating them, is the problem of methodological reflection, in which it is considered that the mobilization of this norm leads men to frustrate the principles that norm assumes. Temporal normative limits. These types of legislative limits imply consideration of the passage of time. We will then have to distinguish two problems, that of outdated standards and that of obsolete standards. We are faced with a norm that expires when it has been surpassed in terms of validity. A norm is outdated when it is no longer in line with the normative principles, and this overcoming derives from the fact that the principles are subject to the erosion of time. We already find ourselves faced with an obsolete norm when it has been surpassed in terms of legal reality. Here, concrete reality no longer calls on these norms to solve legal problems. Whether or not we can recognize an objective, temporal, or validity limit, the same does not happen with intentional limits. These are always present when we mobilize legal norms. Recognizing an intentional limit means recognizing that there is always a distance that separates the norm as a general and abstract criterion and the concrete and individual case. But this distance is not a peaceful zone. It is a genuine field of tensions. It is always necessary to make value judgments when providing an answer to a specific legal problem. It becomes urgent to determine the autonomous merit of the specific problem, because each case is always a unique and unrepeatable experience. Determine the problematic intentionality of the invoked norm. That is, its problematic intentionality, its telos, and also determine the axiological intentionality of the norm. That is, its foundation, its arch. The legal relevance of the obsolete norm depends on the consideration of the institution and the way it is understood over time. Before the jurist proceeded to change the norm, he already knew that the norm was obsolete and no longer effective. Here we compare the layer of legal norm